What to expect at an RTDRS hearing. Refer to the rules of practice and procedure for more details, including the meaning of legal terms such as service of notice. Hearing format. Applications to the RTDRS initiate an adversarial process, much like a court trial. While RTDRS hearings are less formal, the decision of the tenancy dispute officer, who is the adjudicator, is a binding and enforceable judgment. Almost all RTDRS hearings take place via telephone conference call. Ensure the RTDRS has the correct telephone number for you and/or your representative, and, if not, provide the correct telephone number well in advance of the hearing. The hearings are audio recorded. The tenancy dispute officer controls the procedure of the hearing. All parties are required to follow the tenancy dispute officer's directions and conduct themselves in a courteous and respectful manner. Anyone who displays disruptive, disrespectful, or threatening behavior may be required to leave or be disconnected from the hearing. Be aware that tenancy dispute officers hear multiple cases each day, so they may not be able to start your hearing exactly on time. Remain available to receive a telephone call from the tenancy dispute officer for 90 minutes from the hearing start time. The call may come from an unknown, private, Government of Alberta, or RTDRS telephone number. Ensure your telephone will accept the phone call by turning off any call blocking or spam features you may have selected. If you were notified of the hearing but fail to attend, the hearing may proceed without you, and a decision made in your absence. You can have someone else attend and represent you at the hearing if necessary. Preparing for a hearing. Submit your records to the RTDRS and serve them on the other party well in advance of the hearing date. The tenancy dispute officer and the other party need to have time to review and understand your evidence. Serving documents on the other party just before the hearing may result in the hearing being adjourned to a later date. Be sure to submit only those documents or records that pertain to the issues identified in the application, and make sure your records are organized and clearly labeled. Prepare in advance what you will say to the tenancy dispute officer during the hearing. Be able to refer quickly to details in the records that you provided to the RTDRS and to the other party. Remember to have the documents, for example, the application package, applicant's evidence, and respondent's evidence, with you during the hearing, as you will need to refer to them. Witnesses. If the tenancy dispute officer agrees your witnesses could provide evidence of value, the witnesses will be called to give testimony at the hearing, but they will not attend the entire hearing. Ensure your witnesses are aware of the date and time of the hearing and can receive a telephone call. Be sure to have their correct telephone number ready in advance. The best witnesses have personal, first-hand knowledge of the events or facts in dispute. Hearsay evidence is something a person only knows about because someone else told them, and so it has less weight or importance than first-hand knowledge. Introductions. Once the tenancy dispute officer has both parties on the conference call for the hearing, he or she will introduce themselves and the parties. The tenancy dispute officer will confirm the spelling of names, explain the hearing process, and deal with any preliminary issues such as service, adjournments, interpreters, or disclosure of information. Before presenting their case, participants will be asked to swear or affirm the evidence they give will be truthful. The tenancy dispute officer will then clarify the legal issues that they are to decide and review any facts that are not in dispute. During the hearing, follow the tenancy dispute officer's directions. Speak when it is your turn and refrain from interrupting when others are speaking. Take notes during the hearing of what the other party or their witnesses have said. If there are facts that you think need clarification, you will be given the opportunity to ask the other party or their witnesses questions, or to testify as to your own version of the events. When it is your opportunity to testify, explain the facts the tenancy dispute officer needs to know in order to make their decision. Don't assume the tenancy dispute officer knows something that is written in a record. Making your case. The tenancy dispute officer is an expert in residential landlord-tenant law and may explain the law to the parties during the hearing. However, the tenancy dispute officer cannot provide legal advice. While the tenancy dispute officer can ask questions of any party or witness in order to draw out relevant information, it is not the tenancy dispute officer's responsibility to help you make your case. The burden of proof is on the applicant, and the standard of proof is on a balance of probabilities. This means it must be more likely than not the assertions made are true and accurate. If both parties file an application, they both have to prove their claims. If the applicant fails to prove their claim, or if the tenancy dispute officer finds the respondent's evidence to be more credible, the application may be dismissed. Applicant presents first. The applicant will usually be asked to present their case first. The applicant must prove their claim through evidence including verbal testimony and records. A written witness statement without the witness present to testify is not compelling evidence. The applicant will present the information in their application package and supporting records. Explain the basis for their claims and the key evidence. Ask to have their witnesses testify. Answer any questions the tenancy dispute officer may have. Respondent cross-examines applicant. The respondent will usually have the opportunity to ask questions of the applicant and the applicant's witnesses. For example, what date did you move out? Why did I not receive a copy of the move-in or move-out report? At this point, the respondent should ask questions only. Later on, they will have an opportunity to present their own evidence. Respondent presents second. When it is the respondent's turn to present their case, they will explain their response evidence or counter-application, if any, and ask to have their witnesses testify. The respondent's records or counter-application package, if any, must contain all the information the respondent intends to use in the hearing. The respondent will answer any questions the tenancy dispute officer may have. Applicant cross-examines respondent. The applicant will usually have the opportunity to ask questions to the respondent and the respondent's witnesses. For example, how much rent did you pay on the last month? Why did I not receive a copy of the tenancy agreement? Closing remarks. The tenancy dispute officer may allow both parties to make a final closing statement, which is a brief summary of the key evidence and the reasons why you believe the tenancy dispute officer should find in your favor. The reasons should be based on testimony given by the parties and the witnesses' records used as evidence and your understanding of the law. Conclusion of hearing. After both parties have been provided the opportunity to present their case, the tenancy dispute officer will state their decision for the audio record. The parties will listen and not interrupt. Usually, the tenancy dispute officer will answer questions about the decision after they have finished stating it. The tenancy dispute officer will typically give verbal reasons for their decision, and they always issue a written order. An order is a binding judgment that is enforceable once filed at the Court of Queen's Bench. For more complicated matters, the tenancy dispute officer may choose to reserve their decision and provide it to the parties in writing within 30 days. Make sure your correct email address is on the RTDRS file, as this is how most written decisions and orders are delivered. More information is available at www.rtdrs.alberta.ca.